Mr. White is not in here.
No, they're still out there.
State of Michigan versus Devon Watt, 26 dash, or Devin Watt, 26 dash 00264, appearance, please.
Good morning, Your Honor. May it please the court, Dan Smith, appearing on behalf of the people.
Good morning, Your Honor. Trudy Brown Levine on behalf of Devon Watt, he's present standing by.
Okay, today was the date that was scheduled for preliminary examination for criminal sexual first degree false imprisonment and or unlawful imprisonment and domestic violence. And my understanding is there's going to be a waiver to the circuit court. Is that correct?
Yes, sir.
Is there an offer following into the circuit court?
Not at this time.
Okay, and Mr. Watt, you understand that you have the right to have a preliminary examination in this case?
Yes.
And the purpose of the examination is so that you can first require that the prosecution establish whether or not they even have sufficient probable cause to charge you with the felony. So whether there was a felony that was committed and enough to charge you with the felony, understand that?
Yes.
And you would like to unconditionally waive your examination?
Yes.
Okay. Is anyone threatening you to get you to do that?
No.
You understand that once you get to circuit court, if you don't like how things are panning out, you don't get to come back and have your exam. You understand that?
Yes.
Okay, your bind over date is going to be March 18th. That's the date the circuit court is receiving the file from the district court, not a court appearance date for you, unless your attorney files a motion for you to be rearranged, okay? Otherwise, your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that date. Do you have any questions at this time?
No.
Bond is 1,000 personal recognizance that will continue. Any additional matters for the record?
No, Your Honor.
Absolutely, Your Honor.
Thank you. Christopher Taylor not here, or is he gonna come in person?
He was released, so he's not here, and he's not here.
Are you appointed for Christopher Taylor or you
No, retained,
retained?
Your Honor.
Okay, is he coming?
I have not seen him, Your Honor. He bonded out of Eaton County Jail, what I heard last week. We traveled to him on a couple of occasions to his girlfriend and his attorney on an unrelated matter and have not heard.
Okay, we can wait a little longer. It's only been 9 minutes since he was supposed to be here. Otherwise, I'll think more.
I did put a call to his girlfriend this morning.
Yes, we got going on. You got to. Quick work.
Morning, Your Honor.
Morning, how are you? We got all the heavy hitters in there today. What's going on?
Something important must be
Oh, I was
happening in your
gonna
courtroom.
say.
We just finished our packet. Oh, I grabbed them for that. Yeah. We didn't have much going on.
So I'll tell.
Yeah.
I'm gonna grab my computer.
Should I read from here in the hall? I should from that? Yeah. Sounds like it's bored though. Feast or famine.
Right.
Oh, gosh. You said you texted me? Yeah. You don't got nothing to do. Yeah, but what? You don't think so? That he's contagious? He said he can't smell nothing.
Because he's contagious. I mean, because he's congested. He said he's really
Oh.
congested. I don't know. I feel great.
Me too.
Yeah. He wore a mask anyways, though.
Well, yesterday,
Most of the
yeah.
time. That. Since the doctor said she wasn't taking on clients, but she'll get me in.
Oh.
Because whose purple cup is that?
Hmm.
Oh, Anna was in here. So we're just waiting for a 9 o'clock at 9:40. Oh,
They have been talking. all day.
that's why I be rolling in here like I do. Because I definitely got up, but of course I had to go dry my hair, but still. I was like, they ain't gonna be ready. Mr. Johnson, how might we assist you today? Mr.
Who's that? Howard Davis,
Who?
Howard Davis should be PCC.
This morning.
Correct. I'm trying to see if it's on somebody else in the docket. It's not.
Trying to charge.
For Devin Watt.
Or, yes. It's at 9. And then they.
I was gonna ask you to put on GPS down.
Davidson.
Is it Davis or Davidson?
Davis, Yana.
Do you have a case number?
I'm trying to pull it up now. I'll check and make sure I'm in the right courtroom.
That's what we were trying to see. We were trying to see, we'll pull it up in the system.
Thank you. I'll find it.
Okay, thanks.
Sorry.
Figure good.
Okay, on the record in the matter of the state of Michigan versus Thomas Simon, 25-03432, appearance please.
Pete Wadzick, appearing on behalf of the people of the state of Michigan.
Jamie Waiver on behalf of Mr. Simon, who is standing to my right.
Okay, and then, Mr. Simon, my understanding is that you will be entering a no contest plea today to an amended count 1 of misdemeanor stalking, is that correct?
That's correct. Your Honor, do you amend or do you add counts?
We amend,
Oh, correct.
amended, and it says that on here. Amended to misdemeanor stalking under 750.441H. There is a agreement for delayed sentencing for 12 months and that you will wear GPS tether while on probation and continue the no contact order with the victim, correct?
Yes, Your Honor.
Okay, and that's how you want to proceed, sir?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the information you're going to believe or you're going to present is the truth under the penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. Okay, you understand, sir, that you do have the right in this matter to proceed to trial, and you have the right to jury trial. You understand that?
Yes, Your Honor.
You are presumed innocent until proven guilty, and so you can take this matter to trial and require that the prosecutor first prove your guilt beyond a reasonable doubt. You understand that?
Yes, Your Honor.
At the time of trial, you have the right to question or cross-examine any witness called to testify against you, the right to remain silent, not have it used against you, or you can waive silence and testify at your trial if you like, and the right to subpoena witnesses to testify on your behalf. You understand those rights, and that you would have to give up those rights to enter a no contest plea.
Yes, Your Honor.
Is anyone coercing you to enter a plea today?
No, Your Honor.
My understanding is that you are on probation at this time.
Yes, Your Honor.
Until when?
12 months from last Thursday, Your Honor.
Okay. In what, Eaton County or Clinton County?
Correct.
Okay, and have you discussed with your attorney how this plea could have impact on your immigration or travel status?
No matter what.
If you seek immigration or travel status, this plea could have impact on that. You understand that?
Okay. Yes.
Okay, it could, and I don't know if Mr. Wright's already counseled you and that have impact on your probation status, but based on what I understand the circumstances to be, it should not.
Judge Stevens is aware of this, and I gave him my lay of the land on how this would result, and it's the same result, so I don't believe it's gonna be.
Right, because my understanding is they're related.
They're related.
Okay, and so this also could result in a conviction that you may need to report to a current or future employer. You understand that?
Yes, Your Honor.
Okay, and the reason for the no contest plea, my understanding is civil liability, correct, counsel?
That is correct.
That's correct, Your Honor.
As to the amended count 1 of misdemeanor stalking, how do you plead?
No contest.
Okay, I have a police report here. It says that on or about October 4th, 2025, at the area of 311 South Fairview, officers reported for a troublesome subject. The caller advised that on that date, she and her husband were both away from the house. Minor, this person is a minor, correct?
Correct, 15 years old.
Okay, minor with the initials TMM called the parents at approximately 1800 hours. The minor could be heard on the other end crying hysterically due to being frightened. Candace, who's the caller, advised that the minor informed her that she heard something hit her bedroom window. The minor looked out of her bedroom window to see what hit her window and observed Simon standing down in the driveway of the residence. Candace advised that she instructed the minor to go to a nearby bathroom in the house and lock the door. Candace arrived at the residence a short time later and discovered Simon to already have left. Candace also informed officers that on or about September 24th, 2025, the minor had gone to get the mail. The minor came back to the house and appeared to be bothered as she informed Candace that Simon had been there. Candace advised the minor had some strawberries and coffee grounds that had been placed in the mailbox. Candace stated the coffee was 4-ox cinnamon hazelnut coffee, which only Simon would know to buy for her. Candace advised the owner about June 25th, 24th, 2025. Her husband was sitting on the front porch and observed a silver truck driving on South Fairview Ave in Michigan. That's all that's highlighted. That's supposed to be relevant to something. The truck slowed down as it passed in the front of the house, and Candace's husband was able to see Simon driving the truck. Candace advised this appearance in front of her house was also unwanted. The additional factual basis.
Your Honor, the only that it appears that on May 24th was when the contact that the mother had informed Mr. Simon that he is not to have any contact. So all three of the instances that you just raised were after that he was told not to have contact at the time.
Thank you. The additional factual basis.
No, Your Honor.
Okay, you can retrieve your laptop. Thank you. Okay, the court is satisfied with the factual basis. The court also believes the reason for the no contest plea to be appropriate. I'll enter a guilty by way of no contest plea and find it to be plea voluntarily and intelligently made. And there's no objection to immediate sentencing, correct?
That is correct. And just for the record, the victims had appeared, we were consulted, and they were consulted about the immediate sentencing.
Did they wish to make a statement at all?
I don't think they wanted to have any contact at all, even being in the same room with Mr. Simon. So I think they declined that thing.
Thank you, Your Honor. This is a very sad family situation. It's been going on for 10 years. Mr. Simon was already placed on probation at the time of his arrest for this warrant. He was at home in Clinton County, and upon being pulled out of bed, there was a tussle, and he was charged with felony RNO. That was reduced to a misdemeanor. He's, as indicated at the plea, he's been placed on probation with Judge Stevens for 12 months, where he is being monitored. They actually have him doing drug and alcohol testing as well, even though there is no indication of that being an issue in any of the reports or allegations. So I would ask the court set the sentencing date out 12 months from now and not require us to appear if possible, and just have this file closed on or about that proposed date. And notwithstanding violations of the tether. And I did mention to the court the bond conditions that we would ask for a deviation for a particular address that Mr. Simon can provide, where he needs to be there for his employment, that happens to be just on the line of the currently set at.
We have access to our calendar. I've just created a slide. So I did Monday, March 5th at 9. March 5th at 9. Yeah. We'll set delayed sentencing for March 5th at 9. You'll be ordered to during this time, no contact with the victim. And Candace Matthews. We'll continue your GPS tether. Mr. White will provide us the address for JSG of the location that's within the exclusion zone.
I will forward that to the court today, Your Honor.
And then you'll also be obviously required to remain in compliance with your probation. uh, So long as we have no issues, you will not be required to report to sentence.
Thank you.
Write a note saying. Okay, any additional matters for today's record?
Nothing from the people here.
Nothing for the defense room.
Best wishes to you, sir.
Thank you, Your Honor.
Thank you. With the added charge of the person. Okay, so,
Signs infection. You got a sinus infection. I figured that. Oh, yeah, that's what she said. That's not contagious. Yeah.
Yeah, we're looking at the actual charge. To get the language right for everybody. Did you find it? Maybe animal mulch is actual.
That's it.
Is this it? Come on.
I'm assuming this is Mr. Taylor, who's supposed to be here at 9:30. That's what I'm assuming.
Yes, I apologize.
Apologize for why are you late?
I was late because I thought I had court on the sixth.
On the 6th.
Because I had court yesterday and then on my court dates set back to back. And I thought the next time I had to show up to court was on.
Tomorrow?
Yeah, that would be never.
I think I already gave her the bench warrant. What are we supposed to be doing with this case?
We're gonna be waiting, Your Honor.
On the record in the matter of the state of Michigan versus Christopher Taylor, 24-00563. Appearance, please.
Steve Quasi, appearing on behalf of the people of the state of Michigan.
Thank you, Your Honor. Vince Christian, behalf of the defendant, Kristen Taylor, standing to my left.
And Mr. Taylor has a carrying concealed weapon charge that he's going to waive to the circuit court.
That is correct, Your Honor. We are adding a count. My understanding is there's a stipulation to that. There was, looking at our records here, we have a certified copy of prior conviction because this is a weapons offense. We are adding a prohibited person in possession of a firearm. That's a count 2. I believe that's just count 2. Or an added count anyway, and that would be MCL 750 whenever you're ready. I don't know if you're.
Added count 2.
Yeah, 750.224F is in Frank, and that is, again, that's prohibited person in possession of a firearm, and would he be convicted at trial, that would be a 5-year and or $5,000 fine, the mandatory forfeiture of the weapon. So with that, the people will, my understanding is the defendant's going to unconditionally waive his right to preliminary examination. The people will likewise unconditionally waive our right to examine. The case will proceed to the circuit court.
This is an incident from 2021.
That's correct.
That's correct.
Do you want to waive your exam? That's up to you if you want to waive your exam. It's from 2021. Officers are here.
The officers are here, Your Honor.
I don't want to wear my exam.
You can hold your exam. That's what we're here for. They're not offering you a reduction to waive anything. So you're not going to lose out if you run your exam.
Yes, I would like to wear my exam.
Okay, you can call your witnesses.
All right. Your Honor, if I could have the
The exhibit mark.
yes, please. I'll go retrieve witness.
I know one
Okay,
thing.
that makes
He
sense.
makes you think about. ready to proceed?
Can I have a moment, Your Honor?
Yeah, just a quick second, if we could. Just want to clarify their previous offer that we made.
Okay, just want to make sure. Okay.
Very good, thank you.
right rear passenger of the silver Cadillac.
He was the right rear passenger of the Cadillac.
Yes.
All right. And so did you observe him inside the car, outside the car, or something else?
Yes. So he was in the vehicle when the vehicle arrived at the liquor store, and I observed him get in and out of the vehicle several times.
Okay. Several times, more than once.
More than once, yes.
Okay. Did he ever go into the liquor store? Did you recall?
I don't remember him going in the liquor store specifically.
All right. You indicated that he became, that the car became the focus because it didn't have a license plate. It would, at any point, did Mr. Taylor, anything, observations of Mr. Taylor come into focus for you as a law enforcement officer?
Yes, he did.
And what was that?
I suspected he was armed with a firearm.
And how did you suspect that?
So I think it's important just to mention a bit of my background because it certainly plays a factor into my observations with Mr. Taylor. At the time of this incident, I had 22 years police experience, and I had just completed a 3-year tour with Lansing's Violent Crime Impact Team. And in that Violent Crime Impact Team, we certainly specialize in recognizing armed offenders, armed subjects. And in fact, I went to a school provided by the ATF in specifically recognizing subjects who are armed with a firearm.
So you had some specialized training and experience.
Yes.
At that time.
Yes, and my direct observations of Mr. Taylor made me suspect that he was armed with a firearm because I observed him wearing a silver windbreaker. I would describe it as a windbreak type jacket, very loose, not loose, but thin material.
Okay.
And underneath that silver windbreaker, he had on a red shirt, and I remember him wearing a red hat. And I saw that in his right jacket pocket was what I suspected was a firearm based on my observations and training of the object was pulling his pocket down significantly.
So it's a heavy object.
Heavy object, yes. I noticed that it was swinging when he walked in a pendulum effect, which is directly in line with the training that I had received in this type of recognition. And most importantly, the object was so heavy and swinging so much, I would say, almost out of control. While he walked, he made several retention touches in order to steady the object in his pocket, which is those retention touches, just to describe, Judge, what a retention touch is subconscious. The person is touching the item to steady it in their pocket because they're subconsciously making the object closer to them or protecting it from falling out of the pocket.
All right. So fair to say that during your training experience, you drew the conclusion that was a firearm. We certainly factually, just on its face, we know it's a heavy object that subconsciously is important to him. That's what we know at this point, really.
That's right. Yes.
Okay. All right. What happened next?
What happened next is I remember the occupants getting back in the vehicle. Mr. Taylor got in the exact same position that he was in when he arrived, which was the right rear passenger seat. And the vehicle was driven away out of the parking lot and went westbound on Holmes, where we tried to initiate a traffic stop. If nothing else, based on the no plate, the vehicle having no license plate.
Sure.
The vehicle, the driver, who was unknown, did not stop and pulled into the parking lot of the Vons Market liquor store, that plaza. I remember the vehicle not coming to a complete stop, even though we were behind the vehicle with our overheads on. The vehicle slow rolled, I would say 5 miles per hour or so through the parking lot. And then the driver essentially floored it and went to the Pleasant Grove side of the parking lot and fled southbound.
What's the next thing you did?
We did not pursue it in a police type pursuit out of the interest of public safety. However, even though we had slowed significantly down, we could see the suspect vehicle in front of us at a bit of a distance. And I noticed that the vehicle had slowed significantly in the area of Risdale and Barclay. And it was clear that the subjects were going to run.
Right. So let's just break that down a little bit. So you're in the bond market, car flees at an accelerated speed.
Yes.
Public safety, you decide not to pursue at that same speed, but you kept a distance and you were able to visually keep contact with that car.
Yes.
Keep an eye on it, right?
That's right.
All right. So we get to Risdale and Barclay, and your testimony just a moment ago was that I don't know exactly what you said, but something about you anticipated that someone was going to flee from the car, essentially.
Yes. And the reason for those observations is because we could see that the Cadillac was slowing down significantly.
Okay. And so based on your training experience, a bunch of folks in a car, that generally is going to allude to them running at that point.
Yes. They just fled in the vehicle. So now it makes sense from our experience that they're going to flee.
Okay. What happened next?
Based on my observations at the Royal Liquor, suspecting that Mr. Taylor was armed, all three occupants exited the vehicle and fled on foot.
Right. So how many occupants are in the car when they're at Royal Liquor?
There was total of three.
Total of three. So including the driver, everyone at Risdale, Barclay, they all car stops, everybody bails.
That's right.
Okay, please continue.
Ordinarily, the focus would be on the driver because the driver committed the flee and elude, and the driver would be responsible for not having a license plate in these types of observations.
Right.
However, all of that was superseded by my observations at the Royal Liquor, suspecting that Mr. Taylor was under the fire. So as soon as I saw everyone, all three of the subjects flee from the vehicle, I stayed with Mr. Taylor from the back rear seat, right from my initial observations that they're running. We let the driver go.
Okay. All right. What happened next?
With the assistance of, I kept Mr. Taylor in sight, running behind him on foot, and myself and I remember a couple of assisting officers were able to take him into custody behind a house of block Tuesday.
All right. So any resistance, anything like that when taking into custody? What did that look like, you taking him into custody?
I remember him being cooperative. Like there was no physical altercation or whatnot.
Other than the running?
Yeah. Yes.
All right. Very good. What happened next? What happened next?
So what happened next is I was away from the vehicle, but other officers were right there.
Well, let me stop you there. Yeah. You take him into custody. What is the procedure for taking someone into custody as far as making sure that there's safety, officer safety?
Yeah. So he was handcuffed and patted down and searched.
All right. Did the search locate any weapons?
No.
Okay. What was he wearing? You had indicated that he was at the liquor store, the original liquor store on MLK. He was wearing a silver jacket, red t-shirt, red hat, correct?
That's right.
All right. What was he wearing when you arrested?
A red t-shirt.
Okay. Did you have any conversation with him about his clothing?
I remember.
Did anyone?
I remember collecting his clothing and giving his his jacket and his hat. I remember collecting those things, and I don't remember the disposition of his red hat, but I do remember getting his jacket back.
All right. And where did you get the jacket from, I guess is the question.
It was on the ground. He took it off while he was swimming.
All right. Did he make any statements about why he'd taken his jacket off?
No.
All right. Not to you anyway.
No.
Very good.
Not that I remember.
All right. Okay, what happened next?
What happened next is while I was with.
Oh, and just let me go back. You collected the jacket. The jacket didn't have a weapon in it either, correct? Thank you. Go on.
While arresting Mr. Taylor, Officer Slobin indicated to me on the radio that he was with the vehicle.
Hearsay.
Your Honor, I don't think it's being made for the truth of the matter here. He's talking about what the next thing he did. Officer Slobin is here and will testify next. But but as far as my question is, what did you do next? And he's indicating the reason
He's
he did the
explaining
next
why
thing.
he did something.
Yeah.
Okay.
Effect on the listener, I guess.
Objection overruled.
Thank you.
I'm sorry, can you repeat the questions?
Sure. So you were just saying that Officer Slobin told you something and that it affected what you did next.
Yes,
How so?
he advised on the radio that he was with the vehicle and observed a firearm in the right rear passenger seat or passenger area.
Passenger area. Okay. Again, that's the area where Mr. Taylor was observed by yourself. Flee from the car.
Exactly.
Okay. All right. What did you do next?
We placed Mr. Taylor in the back seat of a patrol car that was on scene, and I transitioned from the arrest to.
And what does that mean? Transition to vehicle?
Well, just my focus.
Sure.
Yeah.
Okay. And then what did you do?
I searched the vehicle, and I remember recovering the firearm. And I remember recovering Mr. Taylor's phone. I can't remember off the top of my head what else. I think there might have been another phone in the vehicle.
How were you able to identify that the phone that you find? You said Mr. Taylor's phone. How were you able to identify that was Mr. Taylor's phone?
He asked that I get his phone for. Essentially, it was his property in the vehicle and he wanted it.
Okay. So he conveyed to you that that was his phone.
That's right.
All right. What, if anything, is significance of that phone going forward?
Well, it was very significant.
How so?
So I became the affiant on a search warrant, and which was coincidentally signed by Judge Simmons in this court. And the search warrant was for Mr. Taylor's phone regarding evidence of the firearm that was recovered.
The firearm that was recovered, was it a specific kind of firearm?
It was.
And what was that?
It's actually the common term is a ghost gun. And the reason for that is there's not a specific brand, there's not a serial number or model number. It's just on the internet. It's like I think they call it a P80. There's several versions, but there is no serial number. It's not a traditional manufacturer. And that was this type of firearm, was no serial number and a ghost gun.
You indicated that you were looking for information on his phone that tied him to that particular weapon. Is that fair?
That's true.
And did you find such evidence?
Yes, I did.
How so?
There's photos of the exact same firearm in the phone that was conducted in the extraction of the cell phone.
And when you say the exact same, you just indicated it's a ghost gun. There's no serial numbers or things like that on it, but you feel confident to say it's the exact same. Tell us a little bit more about that.
There should be photos included in the report.
Okay.
If they're not available right now, like there's photos that are going to show clear photos from the extraction that are visibly completely identifiable that it's the same gun.
All right, very good. Okay. Anything else, any other involvement with this case?
No. It's 6 out, sir.
All right, very good. No further questions.
That's the same.
Officer Forbes, hotspot policing could otherwise be considered profiling. Is that correct?
Definitely don't agree with that, Mr. Green.
Right.
Well, hotspot policing is very broad perspective of an area. It's whatever comes in that moment based on our observations. It's not profiling anything. It's just simply watching an area.
I'm sorry, you said it's just watching an area?
Yeah, just observing an area.
Any, okay, I'm sorry, go ahead.
I was just gonna ask a follow-up, but I'll let you continue.
No, go ahead.
But is there certain criteria for where you would do a hotspot policing though?
Yes, absolutely. That would be based on the data of what a high crime area is.
Because it's based on the crime rate in that area?
Yes, exactly.
Okay, right, so it's not that broad, it's kind of narrow. Because you're not just hotspot policing in, places where there's not a lot of crime.
I would agree with that completely. So maybe I misinterpreted the question as far as what profiling means, but we are certainly there on purpose.
And, okay, so the criteria is high crime area. Is that correct?
Yes.
Did you ever ascertain whose vehicle the Cadillac was? Blonde.
Yes. I don't remember the name, Mr. Green, and I don't know why this sticks out, but I remember the VIN coming back to a gentleman out of Sparta. I'm not sure where Sparta is, but I remember that's where it came back to.
But it wasn't connected to Mr. Taylor?
No.
Okay. And indicated that Mr. Taylor was sitting in the back seat and on the passenger side.
Yes.
And you did not know Mr. Taylor at the time, is that correct?
No, sir.
Now, based on your training experience, I noticed you indicated certain criteria that it seemed to be a weapon, but you didn't know that at the time.
Well,
let me rephrase that a little better. Could it have been another object that was not a weapon, a bottle, a tool? It could have been something else, is that correct?
certainly a possibility there.
So you were just, based upon your training and experience, assuming it was a weapon at the time.
Well, it certainly was consistent with my training and experience that it was a weapon, and that's why action was taken to try to stop the vehicle.
And you never saw Mr. Taylor in actual, I know there's different definitions of possession, but never actual possession of the firearm, is that correct?
Yeah, as far as having it in his hand or so forth. No.
Right. And was there any forensic evidence, fingerprints, such as that, gunpowder residue, anything of that nature, that will connect the firearm to Mr. Taylor?
To my knowledge, no. I'm not sure what was done with the firearm.
And the extraction, I guess the other term is dumping of the phone. The extraction of the phone, was Mr. Taylor's the only phone that was extracted? Was it the other individuals' phones in the car extracted? That you're aware of?
Not that I'm aware of, not by me.
And so the ghost gun that you identify, I mean, is it a very rare type of gun or is it relatively, I mean, it's not a rare phone like a certain type of gun, I'm sorry, like a Russian Luger, an Argentinian type of gun. It's fairly popular gun.
I'm not sure the data. Are you asking me from my experience?
Correct.
In my experience, they're certainly more rare than other brands of firearms. Certainly more rare.
Based on your training experience, what is the purpose we found a ghost gun being out there?
Well, I think primarily without it having a serial number, I think that it makes it much more anonymous for the person in possession of it because there's not a serial number associated with it.
And was there any other follow-up with the gun, like it was part of a crime or anything of that?
To my knowledge, no, but I'm blind to that. I don't.
And Mr. Taylor, he never, did you have a chance to speak to him or talk to him about this matter? So the occupants of the vehicle, so it could have been anyone's gun, is that correct? I'm going to say anyone in the vehicle could have been either Mr. Taylor's gun, the driver's gun, or the passenger in the front seat's gun, is that correct?
Well, I certainly wouldn't agree. I think it's way more consistent with my observations, suspecting that he was armed right from the start. And now there's a firearm recovered exactly where it was received.
But again, the gun that was found in the vehicle, you don't know if that was the gun that was in his jacket.
That is true. Other than it doubled down with a search warrant from his phone, and there's photos of the phone, the gun recovered on the back. But in that moment, that's true. I can't tell you that the gun that I observed him suspected of having in his pocket was the exact same gun that was in the vehicle there on scene, but it certainly was proven in the search warrant after the fact.
And again, not trying to be argumentative, but just trying to ascertain. And again, that was the only phone that was extracted by a search warrant.
By me, that's correct, sir.
You're not aware of any other phone?
I'm not, Mr. Green, no.
And again, approximately when you first observed Mr. Taylor, how far away were you from the?
It's directly across the street of MLK. MLK is what, 5 lanes? So each lane approximately 10 feet. That about right? So there's 50 feet. I would say ballparking 100 feet.
You said, was Mr. Taylor, and you're direct, you observed Mr. Taylor get in and out of the vehicle, is that correct?
That's true.
How about the other occupants?
I remember them exiting the vehicle. Yes.
And do you know what the purpose was for any of them getting in and out of the vehicle? If you don't know.
I don't know.
when when the occupants, when you were at Risdale and Barclay, all the occupants, you said, left the vehicle, is that correct?
That's true.
Started to flee and foot. Were you focused on Mr. Taylor or all three occupants?
Mr. Taylor,
And again, because of what you made in your previous observations,
exactly correct.
did you ever lose sight of Mr. Taylor?
I don't remember.
And you indicated that the lease is a cat, and I know you said this jacket was on the ground, is that correct?
Yes.
Ever indicate you why he jacket why he took the jacket off and put it on the ground?
I don't know.
I'm not sure.
Your Honor, Mr. Corpus, do you see that individual you had contact with back on November 27th, 2021 courtroom today?
Yes.
And you just briefly describe what he's wearing and where he's sitting.
Yeah, see to my left wearing a green and white jacket.
All right, thank you. Move for identification.
Any objection?
No objection.
ID is noted.
Thank you. That no further questions.
Thank you. I think former officer Forbes will be excused.
People call Officer Sloman, Your Honor.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. You can state your first and last name and spell for officer.
Officer Alec Slobin, ALECSLOBIN.
Thank you. Sir, what do you do for a living?
I'm a police officer with the city of Lansing,
How long have you been a police officer with the city of Lansing?
9 years.
Back on November 27th of 2021, what was your assignment with Lansing Police Department?
Was working road patrol.
Did you have the, I can't go in there. Did you happen to have any contact with an individual by the name of Christopher Taylor that night?
Did.
Yes.
Yes.
All right, very good. How did that come about?
Officer Forbes had initiated a traffic stop and occupants from that vehicle fled.
What did you do? Where were you in the, it was a Boston unit? Were you with Officer Forbes or in your own patrol car or something else?
I was in my own patrol car.
You were fully marked patrol car at that time?
Yes.
And, okay, so and what was your involvement then in the traffic stop?
I responded to the area of where the vehicle stopped and the occupants fled.
When you got there, what was the status? Was the car still moving? Were people still in the car? What was going on?
The vehicle was stopped and there were no occupants inside the vehicle.
All right. What did you do? What's the first thing you did?
Walked around checking as occupants were still fleeing, assisted with trying to locate them.
When you, this went out as a call on the radio, is that fair?
Yes.
That's where you're doing to go, correct?
Correct.
Were you at part of the hotspot policing that Officer Forbes was involved in, or were you just cruising and doing your own thing?
I was just driving around doing my own thing.
Okay, so you responded to a radio call to come to this location.
Yes.
All right, do you recall the nature of the information that you gained from radio before you arrived? What were you walking into? Did you know?
That they had tried to stop the vehicle and once they were able to, or once the vehicle stopped, occupants fled.
Okay, so that you indicated the first thing you did is kind of walk around that vehicle, is that right?
Yes.
All right, what if anything did you observe?
Observed a handgun, in the rear passenger floorboard.
Okay, do you remember what kind of car are we talking about?
It was a Cadillac sedan.
Okay, so a four-door Cadillac sedan, is that correct?
Correct.
And when you say it was in the rear compartment, which side of the compartment was it on?
It was
Passenger or driver's?
Passenger.
On the passenger side, okay. And you said you're the first one to observe that weapon?
Yes.
And where exactly did you observe it?
It was tucked partially under the front passenger seat, viewable from the back passenger seat window.
All right, so you didn't even open the door, you could look in and you saw it.
Yes.
All right, and what's the next thing you did?
I advised other officers there was a firearm in that vehicle.
Okay. At any point, did you take possession of that firearm?
No.
All right, and what was the procedure there at that point?
It was for the initiating officers, have them handle their call.
Okay,
It's there to assist.
all right, so you didn't walk away from the car, or did you walk away from there? You just kind of guard that gun at that point, or
Stayed by the vehicle.
just stay by the vehicle? And the purpose of that is,
For containing evidence.
right, you
Sure,
don't want
didn't
somebody else
walk
running
away.
and grabbing the gun and running away, right? Okay. All right, were you able to ascertain whether that gun was loaded, unloaded, anything like that?
That I don't know.
That should have, okay. Did you take photographs of at the scene?
No.
If your police report indicated that you maybe took some photographs, would that help refresh your memory, or is that, or are you sure you didn't take any photos?
Sure.
You're sure you didn't take photos? Okay, very good. All right, any further involvement after that?
No.
Officer Forbes came back eventually,
Yes.
and what happened when he came back that you observed?
That's when they took custody of the firearm.
All right, did you have any contact with Mr. Taylor? No.
That I don't recall.
All right, I know he was put in the back of the patrol car, he was not put in the back of your patrol car, that you recall.
That I-
All right, no further questions.
Morning, officer.
One.
Just want to clarify which side you observed you had done in the vehicle.
It was on the passenger side of the vehicle.
Okay, so that'd be, I guess, looking at the right side, right?
Yes.
Right, it was, you said it was underneath, it was on the floorboard,
It was on the floorboard behind the front passenger seat.
but it was enough for you to see in plain sight.
Yes.
Do you remember what type of handgun it was?
I remember it was a semi-automatic handgun.
But you had no involvement as far as forensic evidence with the handgun, such as fingerprints of that nature.
Correct.
You were just there to make sure the gun was secured till Officer Forbes arrived. Is that correct?
Correct.
Nothing.
Any redirect?
No, Your Honor, thank you.
Thank you. May we excuse Officer Slogan?
Yeah.
Any additional witnesses?
No additional witnesses, Your Honor. I do move to admit People's Exhibit 1, which is the judgment of sentence that is under seal. This is signed by Judge Rosemary Aquilina on February 13th, 2013, indicating that the defendant was pled guilty to controlled substance delivery manufacture of less than 50 grams of cocaine in the purposes.
And submitted for statute.
Thank you.
Any other proofs from the people?
No, Your Honor.
Any defense witnesses today?
No, Your Honor.
You can proceed to argue.
All right, thank you. Your Honor, we are here under a probable cause standard, of course, and I think it's pretty clear from the evidence that on November 27th, 2021, that Mr. Taylor, as identified in court today by Mr. Forbes, former Officer Forbes, that he had contact with Mr. Taylor on that date and the location of Risdale and Barclay Place, which of course is in the city of Lansing, Hingham County, Michigan. And that was that at that time he had watched the retention touches at the liquor store, doing the hotspot policing. Hotspot policing is done for the purposes of trying to assess and help people in the community who will live in high crime areas, to reduce crime, to have more contact with the police. That's the purpose of it. And at this particular moment, they had a opportunity to see someone that through his training experience, which was 22 years training experience, and specifically trained on this idea that identifying folks that may be walking around with weapons. Certainly factual that based on his testimony, that he observed something heavy in he identified as Mr. Taylor's pocket, that it was the pendulum swinging and all those things. So it's certainly a heavy object that he was doing retention touches on. And then we watched him get into that patrol car, or that Cadillac in the back seat, back rear seat passenger. That car did not have a license plate and had valid reason to stop. And that stop was initiated. The driver fled initially, pulled into Vaughn's Market, and then fled again. We have testimony from Officer Forbes that he watched that car. They didn't continue to pursue, but he didn't lose sight of it either. Kept an eye on it, watched it slow to the Barclay Bridgedale area. All occupants left. We have testimony that Mr. Taylor started out in with a silver jacket and red hat. Officer Forbes could not remember what happened to the hat, but he did talk about the fact that he had left that Mr. Taylor had left the silver jacket behind. That when he was arrested without incident, brought back to the vehicle, and Officer Slobin had found that the weapon that turned out to be a ghost gun, identifiable by Officer Forbes, both at the scene, and then when he went and got the search warrant, Mr. Taylor's phone, the phone that Mr. Taylor had identified as his own phone himself. Then we were able to take a look at that and find photos of that same weapon that was unique in the essence of the fact that it didn't have a serial number. It wasn't from a manufacturer, it was a ghost gun. So I don't know, well, that's certainly maybe not unique, but it is. But it's there's less ghost guns on the street than there are manufactured weapons. So I think with all of those things put together, that I think by probable cause standards, people have met their burden. And of course, with the People's Exhibit, that Mr. Taylor was a person who was prohibited from having a weapon based on his prior conviction. Thank you.
Thank you. Mr. Green.
Thank you, Aaron. Even a probable cause theory, I think is a relatively weak case. We have 3 individuals in a vehicle that was not Mr. Taylor's vehicle. Any one of those individuals that could have been there prior. I know based on Officer Forbes' training experience, he talked about the pendulum swinging and the object of that type of stuff, but they're focusing on looking at certain things and that can skew what he's doing and what he's looking at. And so again, more of a profile than the community policing. Again, there is no forensic evidence that connects that firearm to Mr. Taylor. They did an extraction of his phone and apparently have something that shows a gun that resembles the one that was found in the vehicle. We have no proof of that. So we'd ask this matter not be bound over.
Today was a date for preliminary examination. Again, the burden is on the prosecutor to establish sufficient probable cause that the felony charge in this complaint was committed, and then probable cause sufficient to charge you in this matter, Mr. Taylor, as the person who committed the felony. This is not a trial. They don't have to prove each element beyond a reasonable doubt, but they do have to show more than mere suspicion that the crimes alleged took place. And I'll be the sole determiner of any credibility issues as it relates to the witnesses. Also weighs the people's likelihood of success at trial. We had testimony first from officer or former officer at this time, Robert Forbes, who testified that on or about November 27, 2021. Again, he was policing in the area at or near. He said it started at MLK and Holmes, it's the Royal Liquors. He was in a fully marked vehicle in full uniform, observing, I guess, from a distance. And he again observed a silver Cadillac without a license plate, observed the defendant or the person identified in this court as the defendant. He stated that he had no prior knowledge of the defendant, but that what stuck out to him again was that the defendant was wearing a silver windbreaker style jacket with a red shirt and a red hat. Is his recollection. I will say that I was shocked about the level of detail and memory that one would have about this case since 2021, but there's a lot of detail. That their defendant had something in his right pocket, front pocket of the jacket, that it was heavy, and Mr. Taylor allegedly was doing what officers refer to as retention touches as he entered the store and then again as he exited the store. And then, of course, as luck would have it, the vehicle has no license plate, so it gives the officers grounds to make a traffic stop. And the testimony of Officer Forbes is that the vehicles did not immediately stop, and that the officers did have to pursue the vehicle a little further into the neighborhood. The vehicle did pull into the Bond Market, I believe is what the store's name is, and then slowed down. Based on the officer's experience, they believe that to be a sign that subjects may be ready to flee from the vehicle. And then ironically, subjects flee from the vehicle and they have to pursue the subjects on foot. The officer did testify that the defendant got into the rear right passenger side of the vehicle when leaving the store. And so he also testified the defendant fled from the rear passenger side of the vehicle that he pursued and did later take the defendant into custody without any uncooperation. And that the vehicle was later searched, or there was a firearm found in the area where the defendant was seated, tucked, according to Officer Alex Logan's testimony, partially under the seat of the right rear passenger. There was a search warrant that was executed or signed in investigation of this and in review of the contents of that phone. Based on the search warrant, officers found photos of the firearm that was found in that area of the rear passenger seat, or photos that matched that alleged firearm, and photos of the defendant with the firearm. The defendant also having already identified that this was his cell phone because he asked the officer to retrieve the phone or get his property out of the vehicle. So in order to find probable cause, the court does look at the jury instruction, carrying a pistol in a vehicle. At the time of trial, the people would need to prove beyond a reasonable doubt, first, that there was a pistol that was in the vehicle that the defendant was in. Second, that the defendant knew that the pistol was there, and third, that the defendant took part in carrying or keeping the pistol in the vehicle. I think I smiled as Officer Forbes was testifying, because I've heard Officer Forbes testify a multitude of times. He always gives a lot of detail. And I was waiting for it. I was waiting for the pendulum effect. And it's never been a situation, and I have, I think, a record of dismissals of probable cause, lack of probable cause. I've never dismissed one from Forbes because it's always an abundance of detail. And then it's always everything aligns, and the subject gives the officer a reason now to search. I agree that there can and be reasonably a question about hotspot policing and whether or not it has some elements of profiling. And I think that it could. I think that this area, however, and what they're doing the police, and I think is a known high crime area. And there's data to support that. And it's also a known area where a lot of firearms are recovered. I don't know how many cases we've had where firearms are recovered from people going into the Royal Liquor Store. And then they had no lawful right to have the firearm. But nonetheless, I also agree with Mr. Green's argument that it could be anything in someone's pockets that's heavy enough to pull it down. It could have been a glass bottle. There's a multitude of things that it could be, but it doesn't mean that it can't be a firearm either. It still gave the officers, I think, enough to maybe watch or question what it possibly was. But however, when the subjects allegedly get into a vehicle without a license plate, and the car is supposed to be pulled over, even that wouldn't have given the officers a right to search the vehicle. But then now there's a fleeing and eluding is what it sounds like of the officers. And then the vehicle stops and all of the parties exit the vehicle, take off running. Firearm left in the area where Mr. Christopher Taylor has been seen by the officer to be sitting. And then the defendant requesting his phone, which is in the property. So he's admitting contents in the vehicle at this point. And then now there's a search warrant, and now this firearm that's located in the area in which the defendant is sitting is now also allegedly seen on data on the defendant's phone. That's a lot of both circumstantial and direct evidence there that the defendant was in a vehicle where there was a pistol, and that the defendant knew or should have known if there was a pistol right at his foot that was in the vehicle. And then based on what was yielded from the police report, and if I were to consider the retention touches and the pendulum effect, that's circumstantial evidence enough to find enough probable cause that the defendant took part in keeping the pistol in the vehicle. So the charge in count 1 plus the people's request to add a count 2 will be bound over to the circuit court for further prosecution. The bind over date is going to be March 18th. That's the date the circuit court's going to receive this file. Your next court date, however, is not March 18th. Your next court date will be set after they receive this file. Mr. Green will be made aware of that date. You got to stay in contact with Mr. Green. He shouldn't have to call people to find you. You retained him. You understand that? Okay, so don't make him have to, plead with the judges not to issue a bench warrant while he's sitting here and track you down. He's been here waiting, to help represent you. So keep up with your court dates. Keep your phone available, or if your phone number changes, or if there's an inability to access you on that phone for some reason, you have the ability to make sure your attorney knows how to get in contact with you. That's your responsibility, okay? Because he's going to get your next court date. And so if he can't get in touch with you, I don't know how you're going to get your next court date. Do you have any questions at this time?
No.
None for the defense, Chair.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
No, Your Honor.
The bond will continue. Thank you.
Retrieve my exhibit here.
You may.
Yeah, try to. Did you? So
I don't know where I will go.
no way.
Code, watch this.
Yeah.
There's that. Oh, well, hopefully
All right, am I done? Anything else anybody needs?
I
this
think
morning?
that's all the criminal we got.
All right. Great. Always a pleasure. Have a good day, everyone.
You too.